The financial collateral regulations were brought into focus recently by the 2nd of November Lehman case. How did the Lehman case change the law?
Well, it's a good question. I'm not sure Lehman changed the law as such, but it did provide or has provided a useful clarification in certain areas.
Could you perhaps summarise which areas those were?
Yeah, sure. Well, I mean, obviously we're talking here about the financial collateral regulations that came into force in 2003 as a result of the EC directive in 2002. The Gray case in 2010 threw into confusion some aspects of interpretation of the financial collateral regulations. So we had amendment regulations passed effective April 2011, and what Lehman has done is provide a really thorough analysis of the legal position.
And what was the focus of the Lehman case specifically?
Well, what it's really focusing on is articulating, in the case of a security financial collateral arrangement, under the financial collateral arrangements, what constitutes delivery and or possession and control. And it looks in great detail at that, following really the confusion surrounding this area post-Gray.
And the Gray case specifically mentioned intangibles. I think there was a change in the law from the Lehman case on that point.
Yeah, so what happened with Gray, which was a case concerning effectively a floating charge over cash, whether you can have, whether a collateral taker could take possession over cash. And the judge in Gray said you couldn't have possession over intangibles, you can only have control. And then, to cut a very long story short, which we try and distill in our article, commentators began to doubt whether you could in fact have a floating charge that qualified as a financial collateral arrangement.
I know as a banking lawyer yourself, you've been trying to take a very practical approach to the financial collateral regulations. Could you perhaps summarise how they relate to margin lending and funds finance?
Yeah, sure. So, I mean, what we try and do, the first thing to say is it should be possible to structure a deal to fall within the financial collateral regulations, providing you're thinking about them when you're putting the deal together, rather than what's happened in the cases where somebody's tried to argue the financial collateral regulations apply. The most important thing is to demonstrate delivery and possession. If you can demonstrate delivery and possession of the collateral in a security financial collateral arrangement, you may not necessarily need to demonstrate control. If you can demonstrate possession and control, that's obviously much better.
So I suppose that takes us back to the Lehman case and floating charges. Do floating charges actually now qualify after Lehman under the financial collateral regulations?
Yeah, I mean, I think they do. Firstly, the amendment regulations adjusted the definition of the financial collateral arrangements such that giving the collateral provider the right to substitute or withdraw excess collateral did not mean that the arrangement couldn't be a financial collateral arrangement. So I think that clarified the position, but I think Lehman has helped us get a little bit further than that. It said, in the case of dispossession of the relevant collateral into the hands of the collateral taker, that's the key test for demonstrating possession.
And what about the part in Lehman about the retroactivity of that particular regulation?
Yeah, I mean, what the case has held is that the laws are there to apply, are not there to apply retroactively. So you look at effectively the date the contractual arrangements have been put in place surrounding the financial collateral arrangement. That's the key date for the purposes of whether the regulations apply or don't apply. What's less important is the point in time at which the relevant collateral secured by those arrangements is placed in the relevant account.
So now that the law has been clarified, perhaps you could talk a bit about what the actual remedies are, so the appropriation, for example.
Yeah, I mean, the really important point on the financial collateral regulations is the modification of English law in areas like insolvency, where if you can get an arrangement to constitute a financial collateral arrangement, the moratorium on administration is removed. It removes the formalities of registration, introduces a concept of appropriation, whereby contractually the collateral taker can agree with the collateral provider that it can take the assets and sell them or apply them towards discharge of debt.
And finally, could you tell us a bit about how that relates to the conflict of law and cross-border element of this?
Yeah, sure. So, I mean, the regulations make it absolutely clear that the relevant governing law for a security arrangement in these circumstances is the law in the jurisdiction in which the relevant account is held, in which the collateral is effectively placed for the purposes of the security arrangements.
Thank you.